Judgment in the matter of Canada Square Operations Limited against Potter.
This appeal raises an important point of law which will affect many thousands of people. The case concerns the mis-selling of PPI policies by banks and is a test case on which around 26,000 other claims depend. Mrs. Potter took out a loan with Canada Square, which was then known as Egg Banking. She also took out a PPI policy and paid a premium for the policy of just under £4,000. Unknown to her, over 95% of that amount was retained by Canada Square as its commission. The amount paid to the insurance company was only £182. Mrs. Potter did not find out about the commission until 2018, 8 years after the loan had been repaid. She then began proceedings against Canada Square to recover the amount she had paid, but she was met with a defence that her claim had been brought too late. The statutory time limit for bringing a claim of that kind is 6 years, so at first sight she was too late. However, the statute postpones the running of the 6-year period where any fact relevant to the claimant's right of action has been deliberately concealed from her by the defendant. It also provides that the deliberate commission of a breach of duty in circumstances in which it is unlikely to be discovered for some time amounts to deliberate concealment of the facts involved in that breach of duty. So far as deliberate concealment is concerned, previous Court of Appeal decisions have held that there can only be concealment if there is a duty to reveal the fact in question. Canada Square was under no legal duty to reveal the commission, but the Court of Appeal held that it was enough if there was a moral or social duty and found in Mrs. Potter's favour on that basis. Canada Square appeals against that finding. So far as the deliberate commission of a breach of duty is concerned, Mrs. Potter accepts that she cannot prove that Canada Square intentionally acted in breach of duty, but she argues that it is enough that they did so recklessly. The Court of Appeal accepted that argument, and Canada Square appeal against that finding also. This court unanimously holds in relation to deliberate concealment that a fact is concealed if the defendant has kept it secret from the claimant, either by taking active steps to hide it or by failing to disclose it. Contrary to previous Court of Appeal authority, the claimant does not need to establish that the defendant was under a legal, moral, or social duty to disclose the fact, nor does she need to show that the defendant knew that the fact was relevant to the claimant's right of action. All that is required is that the defendant deliberately ensures that the claimant does not know about the fact in question and so cannot bring proceedings within the ordinary time limit. Turning to the meaning of deliberately, the court holds that the defendant's concealment of a relevant fact will be deliberate if the defendant intended to conceal the fact in question. The court rejects the Court of Appeal's finding that deliberately can also mean recklessly in this context. On the evidence in this case, Canada Square concealed the commission from Mrs. Potter and did so intentionally. The 6-year time limit for bringing her claim did not, therefore, begin to run until she found out about the commission in 2018. Her claim was, therefore, brought in time. In relation to the deliberate commission of a breach of duty, the court unanimously rejects the argument which the Court of Appeal upheld that something which is done recklessly is done deliberately. Deliberate and reckless have different meanings, both in ordinary language and in the context of legislation. Canada Square therefore succeeds on that argument, but it does not affect the outcome, because Mrs. Potter succeeds on the issue of deliberate concealment. Canada Square's appeal is therefore dismissed. The result will have important implications for thousands of other PPI claims against banks, and the clarification of the law governing the time limits for bringing court proceedings will also affect many more claims in the future.